Ready?
All right. Always have to be.
Oh, well, all right. Well, welcome to the Mineland Reclamation Board meeting for March 2025. This is a public meeting and it's being recorded. Let's start out with attendance of the board. Just indicate if you're here. Mr. Baker.
Here.
Mr. Mock.
Here.
Mr. Oren.
Here.
Said that right, correct?
Yes, ma'am.
Mr. Redden.
Here.
Ms. Stegelmeyer.
Here.
And Ms. Warren, are you with us today on this?
I'm with you.
Thank you. Thank you. All right. So we have a full board here today. So let's get started. The first item on the agenda, and I'm Jill Nelson, the chair. Approval of the February 2025 summary of minutes. Are there any questions from the board on these minutes that were attached to our agenda?
Motion to approve. A second.
All right, all in favor?
Aye.
Any disapprovals? The meeting minutes pass. Then we'll go on to the approval of continuations and withdrawals, which I believe there are none. That was easy. So we'll go into the executive office, director's office report. Would you please, Mr. Moss?
Sure. Good morning, Madam Chair, members of the board, Director Cunningham, Tim Mock, Deputy Director of the Department of Natural Resources. Get comfy. We've got quite a few updates here. First of all, the Department of Natural Resources, we are batting 1,000 on our appointments being confirmed by the Senate. So getting through the Parks and Wildlife and CWCB board members. So for those of you up for confirmation tomorrow, no pressure. It should be just fine. I mentioned the Colorado Outdoor Strategy that we've been working on, balancing conservation, recreation, and engaging climate resiliency. That is nearing completion. We expect that that will be rolled out next month in late April at the Parks and Wildlife Partners Conference. So we're really excited about this opportunity. Legislatively, all of our bills are doing well and making their way through the General Assembly. So I won't go into much details. I've covered a lot of this in the past. However, we will be adding one more piece of legislation to our agenda by introducing soon a Colorado Outdoor Recreation Enhancement Act, which will give Parks and Wildlife some greater long-term ability and capacity to manage outdoor recreation beyond the park system. It'll include officially establishing a non-motorized trails program and establish a river recreation program, among other things, and working with the sponsors on drafting that now, and it'll be introduced as a late bill. Earlier this week on Monday, OSPB released its new revenue forecast, which shows sharp declines in severance tax revenue during the current fiscal year. It's due to large refunds issued to oil and gas taxpayers, and it's likely that distributions to DNR from the severance tax will be near zero in the current fiscal year, 24 to 25. Obviously, we've dealt with the volatility of the severance tax as a major funding source in previous years. We've got some experience with this and are kind of working through some of these challenges. So there might be some changes to some of our programs and how we fund them. Senate Bill 40 was introduced specifically to create a task force to evaluate the future of water funding beyond severance tax dollars. So looking for a larger solution, as those impacts could be quite exceptional to water project construction funding. On the federal side, we continue to track policy changes that are occurring at the federal level. We're also evaluating a proposed interim final rule for the removal of NEPA implementing regulations that is currently out for a 30-day public comment period. The EPA also moved to further limit dredge and fill coverage under the Clean Water Act by issuing new definition of waters of the United States. We understand this change to have a minimal impact on Colorado's water quality protection, given the passage of House Bill 1379 last year, which covers all non-WOTUS state waters. State Land Board is still accepting applications to fill the vacant executive director position. That closes on March 24th. We expect to begin the interview process in coordination with the board during their May meeting. On the forestry side, CoSwap just announced new investments to 19 projects, 14 workforce development, 5 landscape resilience investments. They are located in areas across the state where CWCB Wildfire Ready Action Plan is being developed. One of the larger projects is on Michigan Ditch in State Forest State Park. And the applicant is the city of Fort Collins, and the project is going to be managed by Fort Collins Utilities, but was developed in partnership with State Forest Service, Parks and Wildlife, and State Land Board. On the energy side, February 26th last month, the Energy and Carbon Management Commission adopted the updated high priority habitat maps to inform energy development regulated by ECMC. And the commission started a rulemaking on February 27th to adopt statewide rules to reduce the use of fresh water in oil and gas operations. And then on Friday, they gave a preliminary approval to rules that set targets to reduce freshwater use and include a flexible compliance mechanism. Commission reconvened earlier this week to consider final adoption of the rules in those past ECMC. For tribal updates, the Colorado Commission on Indian Affairs has recently initiated Colorado Lands Works that focuses on statewide repatriation and reinternment requests from tribes. Since the 1980s, DNR and Parks and Wildlife in particular have assisted tribes with repatriation and reinternment requests. DNR is part of the larger work group and will continue to assist as needed with formal tribal repatriation and reinternment requests that are received via CCIA. And then CCIA is also continuing its consultation and greater community engagement for the purposes of updating the state's formal tribal consultation guide. The updates to the state tribal consultation guide will also assist DNR and its divisions on further formalizing internal tribal consultation engagement work and support DNR's strategic priority on tribal engagement and building out a department-wide tribal relations program. CCIA conducted formal consultation with the suit in the Ute Mountain Ute last fall, held 3 community listening sessions in February and March, and we'll be having an inter-tribal consultation meeting later in April. The next CCI meeting is tomorrow, March 20th. And Ute Day at the Capitol is scheduled for April 3rd. If you're interested in attending, the annual event honors the contributions and sovereignty of the 3 Ute tribes. It also celebrates the longstanding government-to-government relationship the state has had with Sioux and Ute Mountain Ute tribes. And then finally, Colorado Parks and Wildlife is hosting its annual Partners in the Outdoors Conference, April 22nd to the 25th, when we expect to roll out the Colorado Outdoor Strategy. And despite finding a much bigger venue down in Colorado Springs this year, once again, the tickets for the event are now sold out. It remains a very popular conference. And Madam Chair, that concludes my remarks.
Thank you. Any questions for Tim? All right. Thank you very much. And now on to Mr. Cunningham and the division director report, please.
Good morning, Madam Chair, members of the board, Deputy Director Mock. With tomorrow is the first day of spring, and with that comes subsidence season. With things thawing out, it is common at this time of year to have some of the historic mine features around the state open up. So our Inactive Mines program has been busy. In the past few weeks, they conducted an emergency subsidence project to assist the town of Williamsburg in addressing subsidence related to a historic coal mine, which was impacting a town road. Pleased to report that feature was excavated and backfilled with concrete and rock and is now stable. But without a doubt, there'll be more of those opening up in the coming months. With that, we are also getting ready to resume water treatment at the Schwarzwälder mine. And so just as a reminder for the board, we put this contract out for bid. We did have some challenges with the contractor and the subcontractor last season, which led us to put this back out. We have selected the new contractor, who is Lincoln. They were our subcontractor last year, so they have good experience with the site, and we're confident they're going to be able to step in and do a good job. That water treatment is expected to resume in the beginning of May, and the contract that we issued this time is for 8 years. As an additional reminder, when we forfeited and revoked this site, we had $7.2 million available to us. After the first season, we've determined our annual operating costs are close to $1 million. So right now we've got approximately 5 to 6 years before that financial warranty would be exhausted. As such, we are having discussions with our stakeholders, with the health department and the EPA about potentially listing this site as a Superfund site. I will continue to give the board updates as we move along there. I also wanted to note that we have been engaging with San Miguel County on their revision of their mining regulations. They're updating their land use code regarding renewable energy and natural resources. I think they really are seeing an uptick in mining interest and exploration for minerals. So they want to get out ahead of this, update their regulations. We've submitted comments on their draft regulations on March 3rd. We support their regulations and the county having oversight within their area. Our concerns were related to issues of preemption with state regulations. So we also participated in a joint work session on March 13th. And the last thing I'll note, as Mr. Mock stated earlier, we get to go over to the Capitol tomorrow for a couple confirmation hearings. Of course, our board chair, Ms. Nelson, will be confirmed for her second 4-year term. Our newest board member, Mr. Oren, will be confirmed for his first 4-year term. In addition, we will have Nick Aramato will be confirmed for his second 4-year term to the Coal Mine Board of Examiners. And I have full confidence we're going to keep DNR Street going. With that, that concludes my report. Happy to answer any questions.
Thank you. Any questions for Mr. Cunningham? All right, well, thank you very much for the update. There is no items on the consent agenda, so we will move into our first enforcement hearing, which is file number M 2009-006. Will all parties who will be involved in this raise their hands, swear to tell the truth, and also state your names for the record?
Jocelyn Carter for DRMS. Amy Ashberger with DRMS.
Jay Panzarella, 41. Brad Ludwig, 41. Bryce Bull, Colorado, 41.
All right, thank you.
And rest me.
And rest means not to be forgotten.
Not to be.
All right, so Ms. Carter, if you would start with the presentation.
Absolutely. My name is Jocelyn Carter. This is for Meadow Hollow Quarry, permit number M-2009-006. The permittee is Colorado Quarry One LLC. This is, and so, pardon me.
Are we able to get it? I don't know if Nell can see it.
I was just about to say something. Yeah, I can see way across the room that it's showing on your screen, but I can't quite read it. I mean, I can pull it up on my computer, but if anyone's joining online or for the live stream, I think you need to be able to show it on the screen. Let's see, almost maybe. Okay,
There you go.
yep, we got it. Thank you.
Full screen.
There we go. Yeah.
Thank you, Nell. So this is an enforcement hearing for the consideration of a possible violation, cease and disorder, corrective action, and civil penalties for failure to protect areas outside of the affected lands from slides or damage occurring during the mining operation.
We'll try to move that.
Here is a general map of where the Meadow Hollow Quarry is located. It's approximately 8 miles west-southwest of the town of Berthoud. The town of Berthoud can be seen on this map on the right side, and the yellow star indicates the location of the quarry. For a permit summary, this is a 110C construction material. They have 9.9 acres permitted. Their commodity is sandstone. The the mine type is surface. Their post-mining land use is general agriculture. And their existing bond is $29,723, which is not adequate. Here is a map of the approved permit boundary. We can see County Road 31 on the right side of this map. The red line indicates the approved permit boundary. The hashed areas of this map show some pre-law disturbance. So the permit does include some pre-law disturbance. And there is a pretty significant sized pre-law disturbance just on the northeast side. That is a quarry pit floor. So here is the approved permit boundary, overlaid a satellite image. This is the most recent satellite image that I could get. It is from May 22nd, 2023. It is not indicative of what is out there today, but that red polygon indicates the current approved permit boundary. And I apologize now, I'm gonna try to move this. I don't know how to make this thing a little bit smaller.
You hit the X on there. That's the
See.
X on there.
The yellow polygon here indicates what I observed to be some land being used for stockpiling product material and some palletized material, as well as some equipment and some sheds and other mining related facilities. And that area was measured to be approximately 1.79 acres. Here's some photos of what was observed out there during my site inspection on December 27th, 2024. The photo on the left, the red line indicates the approximate location of the permit boundary. There is some stockpiled material and then some palletized material. This is looking south on the east side of that pre-law quarry floor. The photo on the right is at the northern extent of the disturbed lands. On either side of the road, we can see palletized material. Some of it is wrapped on the east side of that road. The photo on the left is showing some more product stockpiled, and then in the background, you can see some palletized product material. Across the road, you can see a scale house and some additional palletized material. In the background, I know it's a little difficult to see, but there's this pole right here that's going to act as kind of an anchor point for the next photo. On the photo on the left, we're standing on the south side of that pole in that pre-law disturbance quarry pit floor. The photo on the right, we're on the north side of that pole. We can see it behind the wheel loader. And on the right side of that photo, there's more palletized material. And the area had been graded and improved for moving around the material. The photo on the left, we're further north of that quarry pit. There's some material handling equipment that can be seen on the right. There's the skid steer, and just behind the skid steer is another machine that's used to wrap the palletized material to prepare it for distribution. Again, that red line marks the approximate location of the permit boundary. The photo on the right, we're looking into, to the northwest into the pre-log quarry pit floor. You can see a excavator there was among the product material. And then there's a shed over there. That shed is used to store mostly hand tools. But there were some signs on the shed that indicated some chemicals were also in there. And to the right of that shed, you can see the pole again next to the wheel loader. The photo on the left is a up-close photo of the truck scale and the scale house. You can see some palletized material to the left of that. And the photo on the right shows the another image of the pre-log quarry floor with some palletized material and this excavator. The chronology for this is on December 27th, 2024, DRMS conducted a site inspection. During that inspection, it was found that the operation had affected approximately 1.79 acres outside of the approved permit boundary. The off-site area is being used by the mine for storage of product material, palletized product material, material handling equipment, material processing equipment, a shed for storing chemicals and hand tools, a truck scale, and a scale house. On February 4th of 2025, DRMS sent the operator a reason to believe a violation exists and a notice of the board hearing, and that was received by the permittee on February 13th, 2025. The reason for the violation, DRMS believes that 1.79 acres has been affected outside of the approved permit boundary. This meets the definition of affected land pursuant to CRS 34-32.5-103, parent 3, and Rule 1.1, parent 3. It's also considered to be part of the mining operation as defined by CRS 34-32.5-103, parent 13, and Rule 1.1, parent 30. CRS 34-32.5-116, parent 4, parent I, requires an operator to protect areas outside of the affected land from slides or damage occurring during the mining operation and reclamation. Grants condition and agreement 1 of permit number M-2009-006 indicates the permittee is bounded by all applicable requirements of the Act and all applicable rules and regulations of the MLRB. The permittee has violated this provision of the permit by failing to comply with CRS 34-32.5-116, parent 4, parent I, and can be found in default of their performance warranty. The staff recommendations find the permittee in violation of CRS 34-32.5-116 parent 4, parent I, for failure to protect areas outside of affected land from slides or damage occurring during the mining operation. Pursuant to CRS 34-32.5-124, parent 2, issue a cease and desist order prohibiting any further mining activities except those activities approved by the division in writing as necessary to comply with the conditions of the order, prevent damage to off-site areas, or protect public health and safety until corrective actions have been resolved to the satisfaction of the division. And to require the permittee to submit a conversion application within 90 days of the mailing date of the board's order to include the affected area outside of the approved permit boundary with all materials in an approvable form within statutory timeframes. And lastly, pursuant to CRS 34-32.5-124, parent 7, an operator who violates any provision of a permit shall be subject to a civil penalty of not less than $100 per day, no more than $1,000 per day for each day during which such violation occurs. In this matter, the board may assess a civil penalty of $4,300 to $43,000 for 43 days of violation. This is calculated from the date of the RTB letter, the date of this board hearing. The division recommends the board assess a total civil penalty of $10,750 with all but $500 suspended if the corrective actions cited above are completed to the satisfaction of the division within the required deadlines. Payment of the civil penalties are due within 30 days of the mailing date of the signed board's order, unless otherwise specified in the board's order. Any questions?
Thank you, Ms. Carr. Any questions from the board?
Yeah, Mr. Baker here. The question I have is this 1.9 acres of out of boundary use. It doesn't appear to me that that happened just recently.
Yeah.
I mean, I'm looking at the photos, it seems like that happened or developed over a pretty long period of time. I right?
According to past records, the land that you see there, it has been affected, but the use of that land was never mine related prior to the 2024 inspection. It was always documented to be used for non-related activity, non-mining related activities.
So it was used
It was used by the
and it
landowner.
was developed. I mean, the shed was there and all of these other things that you can see on the photo, those were there, but they weren't used for mining activities.
Correct.
And not all the facilities that were in her inspection photos were there previously. Some of those were new. That just wanted to clarify that the
then-
truck scale and all of the scale.
Okay, then the other question I have is, on the bond, you say it's not adequate.
Correct.
What is adequate?
At this time, we don't know what the adequate amount would be. It would be based off of the disturbance that they have, that's additional 1.79 acres, and whatever they include in their conversion application. During my site visit in December, the operator was actually sat down with me and went over a couple of questions that they had regarding their conversion application. So I had known that they've been working on a conversion application, but with respect to the bond, that will be a more accurate amount will be calculated with that process.
So that's a negotiable amount? It's not an amount that you set?
Correct.
It's an amount that's negotiated between you and the mine operator?
And it'll be based on whatever their proposed plan is. So right now we do have offsite disturbance, so we don't actually have a bond for it because it's not in our jurisdiction. So the point of this hearing would be to get it in our jurisdiction, get it permitted. And then once it's permitted, like Jocelyn said, when we're reviewing this application, they can actually propose some other disturbances as well as they, if they choose to do so. They may make it bigger than what's currently offsite. So she'll calculate that required warranty at that time, just based on what they're proposing through the application. So it'll be based on their proposed plans that they have
Okay,
for that area.
then the only other question I have is, the area you find 43 days ago. So, but was that area being used for mining purposes prior to that 43-day period?
I dated it. I assessed the 43 days based off of the issuance of the reason to believe letter to
Okay,
today. And that,
so, all right, I get it. So it really doesn't matter, but you drew a line in the sand at 43 days. Okay, I got it.
Correct.
Thank you.
Was the bond adequate for their permit area right now without the disturbance outside?
I stopped my inspection, as far as recalculating the bond based off of that, once I discovered that we had some offsite damage, so. I probably wouldn't be up to date, based off of inflation and the last inspection being conducted in 2020.
But your comment about it being inadequate is just because the increased acreage.
Yes.
Correct.
Okay.
And that 1.79 acres, what is the ownership of that?
It is the same landowner
Okay.
for the permitted area.
Is that the mining, is that the mining company or is that a separate owner?
No, it is well, it is a separate owner right now.
So they're leasing the property.
Correct.
Any other questions? So I guess in summary, the operator's been working with you on this matter to go to a 112 permit, and they have the 90 days from whenever this is signed, sealed, and delivered to, and that doesn't seem to be any problem to deliver within that time period.
No, it does not.
All right. Any other questions for the
Well,
staff?
I guess the only other question I have is there an opportunity for the mine to request an expansion of the perimeter to include that 1.9 acres?
Yes, through the corrective action that we're suggesting or recommending, through the conversion application, they can expand the approved permit boundary to include the total disturbed areas.
And there's been some talks, Jocelyn and I have met with them, and maybe the operator can talk about this too when they talk to you guys, but there's been some talks about actually expanding it to include their whole parcel. So they may end up making it quite a bit larger, but we just won't know until we see. I know they're working on the application, so when we get that, then, they'll be back and forth and Jocelyn will do that. But our understanding is they're actually planning to go bigger even than that. So it would cover at least offsite and then go larger.
Mr. Baker, this is Russ Means for the division. A lot of times with these 110s, when we have an issue like this and stuff, what happens is it pushes it beyond that 9.9 acres. So that's why there's a conversion required instead of just an amendment to add in that additional acreage. So it's not uncommon and stuff in that with the smaller one to go outside and stuff and expand beyond that 9.9 acre. And that's why they have to do 112 application. And then from there, they could add in 100 acres if they wanted to, so. But that's the line there and stuff, and that is that 9.9 acres.
And so this 1.79 acres is a little bit of an arbitrary. They may come in with it looks like it kind of swings way over to one side and catches
Right.
stuff. So that'll be redefined by the operator at the time.
Correct.
Operator, you are here and it's not a formal hearing, but if you'd like to shed some light on any of this.
So we recently purchased the quarry over a year ago and are actually in contract.
Do you guys want to come up here?
And if
So
you
they
could
can hear you
yeah,
on the.
State your name
All right.
one more time too.
Yes. My name is Bryce Bull. I'm the owner and manager of Colorado Quarry One. We took over just over a year ago, and that affected area in that like yellow spot, that was actually from the former owner of it. And we actually had to remove all of that material. It's actually old storage units from them, so they took all that away. But what we've done now is we're actually under contract for the land purchase as well. So that's where we want to be able to just do what's right and have the right amount of land, because we know we're outside and we know this is wrong. We just want to fix it and be able to grow it and not have any affected area like this.
And so you said you're working on that contract to purchase, so that's
Correct.
not a done deal yet.
Correct.
Well, I'm
It's
Greg,
signed, yeah.
another one of the owners. We're under contract. We close on April 15th. And everything's going smooth with that, so I don't foresee an issue with it. And then Our goal is actually, when we file for this 112, which we are within the next week, ready to submit, is to include all of the, it's almost 45 acres, to include it all in there to make it easier on you and us. And we were given some wrong information. And we honestly, we just thought we were storing stuff, and we understand that we affected the ground. We understand that that's something that's gonna have to be reclaimed, and that is something that we will do with our 112, if it's accepted, so.
Okay.
So this is a Jay Panzarella, and I'm working with Colorado Corps 1, preparing the 112, which we are substantially far along on that. And the idea is, as he said, we want to get the 112 to cover the full meets and bounds of this property, approximately 44 acres. At that time, with a revised reclamation plan, which will cover all the acreage, we've been working on the estimates of recovery of reclamation, and the bond will be increased at that time. My estimate is that it's going to be significantly increased because we're significantly increasing the property, even though actual extraction may not proceed immediately in some of the additional permitted area. However, the permit area will now cover that affected land and other areas on the property.
I would imagine we'll mine the exact same area that we are right now. We just need more storage space, and that's what most of the 112 that we're getting, we're gonna use, because we've got a great area that we can mine, so there's really no sense in us moving off of that. So I would assume it'll stay pretty much where it's at. You just might see some more land used as storage.
So the expansion of the boundary it definitely includes what's inside the yellow.
Correct.
And the
Correct.
incursion, so all that would be
Yep.
consolidated.
The entirety of the property.
So your entire permit area, you expect to be 45 acres.
A little less than that.
It'll be a little less.
4 point something.
Yeah.
It's a significant increase.
I just want to be clear on something. So you're currently operating it. You bought it, but it hasn't closed.
No, that was the land.
The land, that's
That's the portion. We own the Colorado
Okay.
Quarry 1,
So-
the owners of the operation.
so you bought the mine.
Correct.
And you can operate that.
Yep.
And you will own the land. At what point did you say?
April 15th,
Couple of months?
month, less than a month.
Currently, there is an access right agreement in place with the current landowner, which is an out-of-state landowner.
I assume the landowner has no issue with any of this, or he'd be here, right?
Correct.
I think that's pretty fair.
I think is excited for us to buy the land.
Given that you don't close until the 15th, and I don't know how that might affect your plans or not, does 90 days give you enough time to get the 112 in?
Yes.
I would say within the next 2 weeks.
All right, any other questions? If not, do I hear a motion?
Madam Chair, I'll make a motion regarding permit number M2009-006, that the board find the permittee in violation of CRS 34-32.5-116 parent 4 parent I for failure to protect areas outside of the affected land from slides or damage occurring during the mining operation. That the board issue a cease and desist order prohibiting any further mining activities except for those activities approved by the division in writing as necessary to comply with the condition of the order, prevent damage to offsite areas, or to protect public health and safety until corrective actions have been resolved to the satisfaction of the division. That we require the permittee to submit a conversion application within 90 days of the mailing date of the board's order, to include the area affected outside of the approved permit boundary with all materials in an approvable form within statutory timeframes. And then pursuant to CRS 34-32.5, 124, parent 7, that the board assess a civil penalty of $10,750 with all but $500 suspended if the corrective actions cited above are completed to the satisfaction of the division within the required deadlines.
All right. Go your second.
A second.
All in favor of the motion? Say aye.
Aye.
Opposed, same sign? All right, well, the motion's passed, and we wish you folks well in completing your contracts, and we'll look forward to seeing that permit and see you again soon.
Thank you. Thank you.
All right. We are moving into the enforcement hearing. Is this one step or two steps?
Jared here with the division. We're actually going to have one presentation for both items. Since they're so similar, we don't want to have duplicative, information going out there. So we will combine the next two items basically in
Okay.
one presentation.
So this is item number 6, the enforcement hearing, and item number 7, the enforcement action for the new Elk Coal Company under 2 different files, which I'm sure you'll get into. So all the people involved will still have you swear in, say your names for the record.
Jared, you were
Jerry?
Amber Gibson.
Jason Music.
Scott Anderson for Merrill.
Yeah, thank you. All right, we'll turn it over to, let's see, here. No, turn it over to the staff for your presentation.
All right. Good morning, everyone. My name's Amber Gibson. I'll be representing the division in this enforcement matter. This hearing is for both the New Elk Mine, permit number C-1981-012, and the Lawrencito Canyon Mine, permit number C-1996-084. These sites are both permitted to and were operated by New Elk Coal Company, LLC. And this hearing today is for the consideration of permit suspension for both of these permits. Oh. Hold on. I can put it focus. Okay, it's working. Okay. I'm gonna pull my laser pointer up. Okay. So both of these sites are located west of Trinidad, Colorado, which is about here. And the main mine site for the New Elk Mine is about 30 miles west of Trinidad, Colorado. And that's where most of the surface facilities are and the access to the underground mining. And then coal would be loaded on trucks and then driven on Highway 12 all the way over to this little spot just east of Trinidad Lake. And that's where it would be loaded onto rail and shipped out from there. And then the Lawrencito Canyon Mine is in between those 2 permit boundaries for New Elk, and it's about 18 miles west of Trinidad, Colorado. So as both of these sites are permitted to New Elk Coal Company, I'm just going to do a brief overview of both of them so we can kind of get an idea of what we're talking about. So I'll start with the New Elk Mine. This one was operated as an underground coal mine, and it encompasses 4,213.6 acres. When it was in operation, its last reported production was in June of 2023. But the last date with New Elk personnel on site was July 18th of 2024. So in that interim time, it was more just maintenance duties being implemented on site. And the post-mining land use for the site is a mixture of both rangeland and wildlife habitat. And the bond that we hold is $5,218,954. And the bond is in good standing with the surety company at this time. So the pink polygons show, oh, it's kind of hard to see, but this shows the permit boundary for the New Elk Mine. So it's in 3 little chunks. Well, this big chunk is the main permit site area for the Newark mine. It has the majority of the surface facilities and also the access to the underground mine workings in this portion. And then just to the east, there's a little 3-acre sized area, and that is mostly reclaimed. And then this is kind of a zoomed in polygon of the Jansen loadout area, and that's where the trucks would bring the coal and then it get loaded onto the train. So we're just gonna zoom in and look at the main surface facilities. And once you're on the main site, it's usually referenced as having west facilities and east facilities, with the majority being on the east side. So we're just gonna look at those first, but I just want to preface it with, again, reiterating that there are no ongoing mining operations and there are no personnel on site. So I'll just kind of give you an idea of what's there and how it was operated, but it's not currently occurring right now. Ooh. Okay, so first there are 5 ponds on site, 3 of which are used as sediment control ponds. One of them is used to store water pumped out from old mine workings. And then the other one is used in association with the wash plant. There's also 2 development waste piles on site. And then there's 1 refuse disposal area as well. When the mine was operating, there was a raw coal storage yard where the raw coal would be brought to the on-site wash plant. And then from there, the clean coal would be deposited into the clean coal storage yard. And then the refuse generated from the wash plant would be conveyed up to the RDA, or the refuse disposal area. Also on site on the east side are 2 portal accesses. There is the East Allen portal, and there's also the Bates portals, and those are the ones that were most recently used on site. The majority of the west facilities have been reclaimed, with the exception of the West Allen portal and the associated fan house. Okay, so now I'll go over the Lawrencito Canyon mine, again, also permitted to New Elk Coal Company. In contrast to the New Elk mine, though, this one was operated as a surface mine. And this site has been in permanent cessation since 2003. So in coal, when a site's in permanent cessation, that means that they've reached full reclamation and that there's no ongoing mining activity. The permit area remaining at this site is 384 acres, and the post-mining land use is rangeland. We hold a bond of $927,121, and again, it's also in good standing with the surety company. Okay, so when looking at the Lawrencito Canyon mine, the mine itself was operated for about 9 months as a surface operation, but it's been mostly reclaimed since 2001, and it's been in permanent cessation since that 2003 period. But there are still a few features on site, so I will just go over those real quick. 6 of them are sediment control ponds, and then there's also a few valley fills on site. Okay, so as both of these sites are permitted by New Elk Coal Company LLC, I just wanted to give you guys a little bit of a background of what's been going on with that company. So on February 21st, 2023, Allegiance Coal USA Limited, which is the parent company for New Elk Coal Company, filed for Chapter 11 bankruptcy. Then on March 5th, 2024, the division received a resignation letter from the last remaining New Elk Coal Company officer. And then on July 25th, 2024, the bankruptcy case for Allegiance Coal was dismissed. So the enforcement process in coal is a bit different than in minerals in that violations are found and issued at the staff level. So I just want to go through the enforcement steps that we took that brought us here before you guys today. So starting with CRS 34-33-110 parent 5 and per rule 2.03.9. The permittee is required to hold a public liability insurance policy at all times and in full force through the life of the permit. But upon determining that the insurance policies had expired at both Lawrencito and New Elk, the division issued violations. And then in order to abate those violations, New Elk was to submit a certificate certifying that they had a public liability insurance policy in place, or they could have provided evidence that they satisfied applicable state or federal self-insurance requirements. But after multiple extensions, which totaled the full 90 days allowed by Rule 5.03.2, Parent 2, Parent B, the permittee failed to abate those violations. So as a result, the division then issued a failure to abate violation cessation order for each of those permits. And then the permittee failed to abate those cessation orders. So at that time, the division administrator, our director, issued a pattern of violations pursuant to the requirements of Rule 5.03.3, Parent 2, Parent A, Parent I, and issued a show cause order, which instructs New Elk Coal Company to show cause as to why the permit should not be suspended or revoked. However, we did not receive a response to that show cause order, so the division set the matter for a formal public hearing before the board. So now I'll just go through like the actual chronology of those events. So starting on May 2nd, 2024, the division conducted a complete inspection of the Lawrencito mine. And as a result, on May 30th, 2024, we issued a notice of violation for failure to maintain that insurance policy. On June 12th, 2024, the division conducted another complete inspection, this time for the New Oak mine. And then on June 20th, 2024, the division sent another notice of violation for that same failure to maintain a certificate certifying that they had that public liability insurance policy in place. Then on August 12, 2024, the division became aware that Lightfoot Resources LLC was interested in acquiring the permits. And then on August 28, 2024, the division or the violation cited at the Lawrencito Canyon mine reached its resolution date, but we did not get an abatement. So on August 29th, we issued that failure to abate violation cessation order for the Lawrencito Canyon mine. On September 18th, 2024, the violation cited at the New Oak mine reached its resolution date. And again, we didn't receive an abatement. So the next day on September 19th, 2024, the division issued a failure to abate violation cessation order again, this time for the New Oak mine. Then on September 30th, 2024, that's when the division issued that order to show cause as to why the permit should not be suspended or revoked. And on that date, it was issued for both Lawrencito and New Elk. And then on October 25th, 2024, the division published that show cause order in the Chronicle newspaper. And on January 27th, 2025, the division became aware that Lightfoot Resources LLC was no longer interested in acquiring those permits. So then on January 29th, 2025, the division sent a notice of formal public hearing for both Lawrencito and the New Elk mine. And then on February 26, 2025, the division met with Eldon Strid, who's in attendance today, and he is a mine consultant for the Hill family. And the Hills own the land that the Lawrencito Canyon mine is on, and they're also the majority shareholder for the subsurface mineral rights at that site. And Mr. Strid informed us that they're actively working towards acquiring the assets for New Oak Coal Company, and they intend to take over the permits and abate those violations once they do so. Okay, so since the staff has exhausted our enforcement authority in this matter, and because the permittee has failed to abate the initial violations and the cessation orders, the division issued that show cause order. And we did not receive a response from the permittee. So pursuant to CRS 34-33-123 parent 7, CRS 34-33-124 parent 4, and Rule 5.03.3 parent 3, following the issuance of an order to show cause as to why a permit should not be suspended or revoked, the board shall provide an opportunity for a public hearing. And then per Rule 5.03.3 parent 3 parent B, if the permittee does not file a response and request review, the board shall make findings of fact and issue a written decision and the reasons therefore concerning suspension or revocation of the permit. So since we do have an interested party and that's actively working towards acquiring those assets, and they want to acquire New Elk and Lawrencito permits, we would ask that you exercise the suspension option on this rule. Also pursuant to CRS 34-33-124, parent 4, and Rule 5.03.3, parent 4. If the board suspends the permits, the permittee shall immediately cease all surface mining operations. However, since we already issued those cessation orders and they haven't been abated, and since currently there is no active permittee on these sites, we're not asking the board to make a finding in this matter. But also pursuant to this rule and the statute, the board does have the opportunity to forfeit the performance bonds today. But I just want to say that the division does not recommend that the bonds are forfeited today. We don't believe it'd be in the state's or the permittee's best interest at this time. With the caveat that the division will set up another hearing in the future for a consideration of permit bond or performance bond forfeiture, should the acquisition of the New Oak assets not occur. So in summary, the division recommends that the board suspends permit numbers C-1981-012 and C-1996-084 pursuant to CRS 34-33-124, parent 4, and Rule 5.03.3, parent 3, parent B. Also, to reiterate, the division does not recommend that the performance bonds are forfeited today. And then we also wanted to highlight another thing that's a little bit different from minerals in that the board order is held to statutory timeframes. So pursuant to CRS 34-33-124, parent 4, and Rule 5.03.5, parent 4. When a hearing has been held on a show cause order, the board shall issue and furnish the permittee and other parties to the hearing within 60 days after the close of the hearing, a written decision and the reasons therefore concerning suspension or revocation of the permit. And before we go to questions, I just wanted to mention that we do have a few interested parties here today. We have Mr. Strid, who is that mine consultant for the Hill family, as well as the Hill family's attorney, Mr. Anderson. And then virtually, we also have Daniel Waxman of Indemnity National Insurance Company, who holds the sureties for both of these sites. Now I'm ready for questions.
Any questions from the board?
I'm a little confused about the insurance part. If, because it's no longer functioning, right?
Right, there's not a policy in place. It expired in April.
Maybe explain the difference between the insurance and the bonding mechanisms.
Okay, yeah, so the bond, like the performance bond, that is what we hold to perform reclamation should the site be forfeited. But the public liability insurance, that's their insurance policy to, protect public health and environment, should like something occur.
Yeah, under Rule 2.03.9, that kind of outlines what that's for. And it's personal injury and property damage insurance. Think of it kind of like a general insurance policy like you'd have on your home. Like if someone came to your home, got injured, it would cover their injuries essentially. And they're required to maintain that through the life of the permit. That's in full force and effect.
But it's expired.
Yes.
Okay.
For both sites.
Yeah, and then the company went away. Like the permittee is no longer
Right.
existing.
So the suspension of the permits allows time for the Hill family to get through the legalities of buying the assets and then coming in and asking for a transfer of the permit to their name.
Yes.
Or to whoever they come in and that would, in order for that to be reinstated, it would require that certificate of insurance amongst other things to be in place again.
Yes, yeah, they would have to abate those violations, get that insurance policy, also put up the bond, and then there's a few other things that they would have to do through the application process that we need to get finished before they can officially be the permittees, but that is the reasoning behind suspending the permits rather than revoking it.
Other questions?
The suspension is for time period to be determined depending on what happens.
Essentially, yeah. So there aren't statutory timeframes of how long something could be in suspension. But we intend to work closely with the prospective buyers so we can kind of get an idea of their process throughout this whole situation. And again, if it starts to get closer to the date where we're not getting comfortable anymore with that, the fact that this isn't going to go through or something like that, then we will set it up for a separate hearing for actual revocation and to forfeit those performance bonds.
Any comments from the Hill family representatives? Thank you.
Oh, either way. Yeah.
Wait, what? What's going on?
Just gonna come
Okay.
next to us. I mean, more questions.
Okay.
Hi, good morning. Thanks for letting us explain what we're up to here and what the 60 days does. So my name is Scott Anderson. I'm the lawyer for the Hill family. We said we were with Premier Coal. That's an entity that the Hill family has formed to advance this project. Eldon Stritt is our mining engineer. He knows all the facts on the ground, so he'll tell you about that stuff. But just to explain the process we're looking at here and sort of how we're in the spot we're at. The Hill family has the ranch immediately adjacent to New Elk property. That's where the Lawrencito mine was set up. So that's actually on the Hills property. The Hills are looking to develop their metallurgical coal under the ranch. They'd done a transaction with Allegiance when they had New Elk, and obviously that fell apart as Allegiance went bankrupt. Part of the impediment we have is that New Elk Coal Company is not a functioning company. They don't have anybody representing them. It's just a shell. There's nothing going on there. So you can't do anything with New Elk. That's why they're not answering the division when the division sends a notice. There's no there anymore. So what we've decided to do, there's an entity called Collins Street. That's an investor that made a big loan to Allegiance. And they hold a deed of trust and a UCC financing statement, so a security interest on the New Elk assets. Because New Elk's bankrupt, the bankruptcy court dismissed the bankruptcy, but the companies that had the security interest in the property maintained their security interest. So Collins Street still has a deed of trust and a UCC on the New Elk assets. We are in active conversations with Collins Street to basically have them assign us their deed of trust. So we'll become the secured party. We'll foreclose on the deed of trust and then take ownership of the assets. So the 60 days doesn't give us enough time to do all of that. That'd be at least 120 days from the time we start the foreclosure to the end of it where we'll actually take title. But what the 60 days does is give us enough time to see whether this is going to work. Like I said, we're in active conversations. We've agreed to commercial terms. We're drafting the documents for Collins Street to look at for us to step into their deed of trust. So right now, it looks like that's likely to advance. You never can tell, right? But so far, so good. They're very keen to have this happen because their deed of trust right now has no value, right? And they're an Australian lender. They have no interest in coming to the United States, spending more money on lawyers to pursue this. They've washed their hands, right? So if we can come in and take the deed of trust from them, we'll bear the cost of foreclosure process. We'll bear the risk of foreclosure process. They'll get whatever we give them commercially as part of that transaction. And then we'll step in. And once we take title, then we'll ask to become the permittee. We'll provide the insurance. We can't do that now because we don't have any ownership interest. But when the time comes, we'll come in and be effectively the operator of the New Elk assets and do some of the remediation we're looking at along the way. So that's the plan. And again, I want to be very clear about what the 60 days does. It doesn't get us to the end point. But then we'll come back in 60 days. We'll be in constant communication with the division to let them know where we're at. If things work the way we hope to, my personal view, I'd love to have started the foreclosure process within that 60 days. Kind of depends on how, the transactional component works. But if not, we'll be close to that. So in 60 days, we'll know, it'll be go, no go by then. We'll know whether this is going to work or not. And we'll come back to you and let you know whether we're advancing it. So that's, a little bit creative, but that's just the nature of the hand we've been dealt, right, to get there. So that's what we're up to. So that's the plan. And again, the suspension, we've been talking to the division. That just gives us enough time. The only risk to the division, the state, is that 60 days longer before you pull the bond. If this falls apart, you'll be right there in 60 days. So that's what we're trying to work through.
Thank you. Any questions around that? So if we grant this motion, this will allow 60 days, then what is the step to give an extension to that?
So, Ms. Nelson, Jason Music with the division. Just kind of want to make it clear what suspension does. So there's no timeframes on suspension as Amber mentioned. What suspension does for the division though, is it provides the division the framework to do anything we need to do. Whether it's forfeiture, there's not a time frame. The 60 days is a time frame that the interested party has set based on what they understand is going to be allowable with Collins Street and the foreclosure process, which is on after that. We recognize all of that. But I want to be clear on the suspension portion of it and what it means for the division. Really, the suspension, all it allows us to do is not revoke the permit. So if in fact we didn't have a permittee on site or a permittee or an entity that was interested in the permit, we would go to revocation. At that point, if someone wanted to come in and take over the permit, well, they would then come in and put a whole new application together. I mean, it's an effort in futility, really, because we already have 2 applications ready to go right now. So by suspending, the division has the opportunity to, for one, statutorily address everything that we can do under revocation without revoking the permit. Under suspension, we can still forfeit. If in fact, in 3 days, we find out something can't happen, we can still forfeit the permit under suspension. It doesn't have to be revoked to forfeit the permit. Okay. And we can run it through suspension during reclamation, during forfeiture, during the entire process without revoking the permit. What it does for the division also is it provides an opportunity to cut back on the statutory and regulatory responsibilities of the division. For example, reporting requirements. There's no permittee. There's no one to report information.
Right.
Midterm review documents, renewal documents, those kind of statutorily required reporting documents that we need. Well, they don't need to be submitted. So then that cuts back, as you're aware, we're oversighted by the Office of Surface Mining. So then that takes their oversight capabilities away. There's nothing for them really to oversight because the division, either whether it's suspension or revocation, is responsible for the permit. So that's kind of what suspension does. It doesn't, but there's not a timeline on suspension. We're not holding this to a timeline. If in fact, in our discussions with the potential interested party, we come as a division to realize maybe this isn't the case. Maybe this isn't going to happen at any point in time. We could reach out to the surety. We could determine if there's a forfeiture. We could determine if there's not a forfeiture. We have that jurisdiction. So I just wanted to be clear on the timeframes. There are timeframes associated with them, but not with us. We don't have timeframes associated with suspension.
And there's no operations going on during any of this?
That's correct. 0 operations. I think Mr. Shank can talk to the discussions they've had on potential security of the site, those kind of things. But the site is secure in so much lock gates, barbed wire fences as any site would be, but correct, there's no activities occurring on site. There's no maintenance items on site. And that would be one of the compliance requirements for a new permittee. The benefit is they don't have to submit a whole new application. But they are going to have to bring the site into compliance, and that includes the liability insurance, but also any on-the-ground maintenance that needs to be done to bring it into compliance will have to be done prior to us approving a new permittee.
Yeah, if I could just add one thing to that real quick. I mean, the other thing is once you revoke the bond, you got to start reclaiming. We're very interested in the wash plant. So when you take that down, then the value goes away. So part of it is just to prevent the reclamation of the site and removing the structures that are going to be useful to us going forward. So that's another reason why we need to book a bit of time so we don't start having dozers around or pushing stuff around that we'd like to keep in place.
So the eventual intent is to operate it again?
Yeah. At least the surface facilities. I think the mine, I'll defer to Eldon on that. But
well, a longer term objective here is the Hill family owns the surface and has rights to the minerals at Lawrencito. That's about a 17,000 acre tract that was permitted originally as an underground mine, plus some limited surface workings. The underground mine at that time was never begun. And the surface workings that Amber talked about a little bit earlier was all that was done. And what those previous operators chose to do is to reduce the permit area from the original 17,000 acres to what it is now, the 300 some acres. And what we're interested in doing on the Primero coal side is to amend that existing permit for an underground operation. That coal that's present there is metallurgical grade. It fits into the seaborne market. And the reason that Primero Coal is interested in the balance of New Elk assets, particularly at the New Elk site, is as Scott mentioned, is there's a wash plant there that's in good working order. This coal would need to be washed. And then there's coarse refuse or a refuse disposal site that's included in that permit. And those two components are key to being able to be effective at the Lawrencito site.
Any other questions?
This is sort of irrelevant, but I'm just curious because in the pictures, it's mostly flagstone and not coal, but the interest is coal and the flagstone on the surface.
No, that was the other project. That's not.
That was the last project.
Oh,
We're only coal.
Yeah, we're new guys.
okay. I guess we didn't get those pretty pictures.
No, we
They're
don't.
underground mines. Yeah, so everything at that New York site that was mined is underground, so I don't
Uh-huh.
have.
Okay, we didn't get pretty pictures of rocks.
And there's not a plan to continue mining at the New Elk
It
underground?
doesn't sound
No.
like that's a.
No. That quality coal there is suitable for thermal use. And the market wouldn't support that development.
Any other questions? So in this written decision, does the, it says with recommendations, does the recommendations just go from your report, or do we need to do recommendations to support this suspension?
There's a suggestion motion at the very back of your
Yep.
packet. That's really all we're asking for.
Okay,
There's
that's all you need.
Nothing in
That
there.
makes it easy. All right, so do I hear a motion?
One motion that we accept it.
Okay, would you please read the motion just read this piece for the record, please.
Motion to suspend permit C 1981-012 and C -1996-084 pursuant to CRS 34-33-124-4 and Rule 5033B.
All right.
I think I
Here's
read it
that.
right.
That motion.
I'll second that emotion.
All right, all in favor, say aye.
Aye.
Opposed, same sign. All right. Thank you very much. Very
Thank you.
interesting,
Yeah.
change of pace for us. All right, so, do we need to take a break or can we continue on? We got 30 more minutes left.
I think it was right.
Okay, so let's take a break till 10:25 and come back at that time for item 8, which is a discussion item. Thank you.
In my head, I want to be picturing the flag stick.
Yeah.
And never.
Did you get the PowerPoint?
It's PDF.
Okay, should be.
Hopefully make it into management.
Okay, I'll do a brief introduction and stuff in that, and then I'll turn it over.
Okay.
Hi. But we were kind of in a hurry. Project down there. We've run into a lot of bureaucratic.
No, I'm sure it is. I'm sure it is. I know all about it.
Oh.
Driving him nuts.
But other than that.
Good, how you doing?
Yeah.
Can everybody online see the screen okay?
Yep, works for us.
Perfect.
Okay, you ready, Ken? All right, so let's get back at it with discussion item with Mr. Trujillo, who's going to give us an update. Thank you.
Yeah, I believe Russ was going to give a little bit introduction, but I believe
He's talking.
he might be.
He's up.
Well, now he's coming, so we'll give him a wait. If not, I was going to go ahead and fill in.
Go get the hook.
Good morning, Russ Means for the division, as well as Zach Trujillo. We're here today and stuff to present to the board, the reclamation awards and stuff for Hard Rock, and also coal, as well as the Jim Pendleton Award. The board, we kind of touched base on it and stuff earlier, but annually, the division hands out work and stuff with the Colorado Mining Association, reclamation awards and stuff for Hard Rock, as well as for coal for meeting major milestones in reclamation, as well as overcoming hurdles and stuff that in doing those tasks, as well as recognizing someone in the mining community for their outstanding work in reclamation. This year, the SME, we present every year and stuff at the CMA luncheon, which Chairman Nelson and stuff was at. And this year and stuff was in conjunction with the SME, the Society for Mining Engineers. It's a biannual event and stuff that happens here in Denver. And then CMA does their own on the opposite year and stuff and that rotates around the state and stuff. So we're here today and stuff to honor these projects, as well as our recipient for the Pendleton Award. And with that, I'll turn it over to Zach and let him go through the presentation. And then I'll finish up and stuff with it. So.
Okay, thanks, Russ. Yeah, as Russ kind of mentioned, the DRMS CMA reclamation awards are open to all companies that basically are engaged in the mining and reclamation of permitted coal and hard rock sites. So we're kind of here today just to kind of highlight and commend the efforts of the industry's commitments and achievements of high-level reclamation success across the state of Colorado. As part of that recognition, the division is honored to award companies that have gone above and beyond in order to achieve reclamation success over unique challenges, as well as the implementation of new technologies. So we present these on an annual basis, and we basically have broken these down into 3 reclamation category awards. The first being overcoming a unique challenge, second being advanced technology or attempted technology to improve the reclamation process, as well as developed or continued substantial community partnerships. As Russ mentioned earlier, we also award the Dr. James A. Pendleton Award, and that goes to an individual who has achieved substantial achievements in mining and reclamation in the state of Colorado. So with that said, as we kind of mentioned, Russ, this year's was in combination with SME and SMA. And so these were kind of the awards that we, in the nominations and the awards that we presented. So in the category of overcoming a unique challenge, the division recognized the Climax Molybdenum Company's achievement in successful reclamation at high elevations along rugged and steep terrain at the Henderson Mine. With the collaboration between diverse teams, Henderson Mine was able to dismantle and airlift massive steel structures from an old mine shaft located along adverse terrain and high elevations. Despite the steep terrain and altitude challenges, crews safely removed 3 5,000-pound steel rings from the remote and high alpine location. With the use of a helicopter, the 3 rings were moved over the Continental Divide to the Henderson Mine main facility area, in which they were then recycled. With the mine shaft near popular hiking trails, the 1,600-foot shaft was then sealed and reseated to ensure public safety. And as you can see here, you can kind of see the crews and the helicopters, as well as the plugging operations and end of reclamation that was performed there. So I believe this was upwards of over 10,000 feet high is where the shaft was located at. Second, in the category of the advanced technology or attempted technology to improve the reclamation process, the division recognizes the Mountain Coal's achievement in implementation of targeted vegetation management and reduction to promote wildlife habitat and to mitigate fire risk for the area at the West Elk Mine. A total of 225 acres were surveyed for either clearing, mastication, or retention based upon vegetation identification and areas ideal to assist in mitigating the spread of wildfires along high, rugged, and hard-to-reach terrain. The project partnered and collaborated with multiple entities, which included the West Region Wildlife Council, Lazy H Ranch, Colorado State Forest Service, and the Western Timber Management. The planning for this project took almost a year to coordinate and implement with all entities involved. And as you can see, here's some overlying areas in which they either maintain certain vegetations or they mulched or masticated certain areas and in hopes to be able to create some buffers to key areas to help mitigate fire risks in that region if one were to occur. So unfortunately, this year we had no nominations for the developed or continued substantial community partnerships, so none were awarded. However, we were happy to award the James A. Pendleton Award to Basil Bear this year. Basil Bear is a lifetime North Fork coal miner who grew up in Paonia, Colorado. Basil was born into a multi-generational coal mining family, and after graduation from high school, Basil started working for his father and uncle at the Bear Mine in Somerset, Colorado. He started full-time at the Bear Mine in 1979, and he developed his career there, experiencing every aspect of coal mining. With the closure of the Bear Mine in 1997, Basil went to work at the Bowie No. 1 mine. Shortly thereafter, he was involved with the opening of the Bowie No. 2 mine. During his tenure at the Bowie No. 2 mine, Basil oversaw the surveying and environmental department, along with leading the mine rescue team. Basil was closely involved with the reclamation of the Bowie No. 1 East and West mines and was able to oversee those sites until near complete bond release in 2022 and 2023. Basil also oversaw the reclamation of coal handling facilities, the Bowie No. 1 loadout facility, where he implemented concrete recycling practices with the removal of the storage silos. The practice of recycling the concrete was novel at this time, but has now become standard practice during the mine reclamation projects. During his final years at the Bowie No. 2 mine, Bowie oversaw contemporaneous reclamation of the waste rock disposal sites and managed the day-to-day site maintenance and monitoring program. Basil also worked with a multitude of regulatory entities, such as the Division of Reclamation, Mining Safety, and Water Quality Control Division. And due to his due diligence, the two Bowie mines managed to stay in compliance with the rules and regulations of these agencies. Basil officially retired in July of 2024 after a distinguished 45-year career improving the practices and operations, as well as reclamation of coal mining in the beautiful North Fork Valley of Colorado, which he has been able to call home his entire life. And so that would conclude this year's winners for the Reclamation Awards, as well as the Jim Pendleton Award. Any questions?
Do they self-nominate or how's the nomination kind of process look?
Great segue, thank you. The operators can actually self-nominate, but staff also, as they're doing inspections throughout the year, are taking a look to see if they can identify those kind of things that will qualify, or even if they might and stuff, we can come back and talk about it. So over the years, the number of nominations, the number of awards we give out kind of ebbs and flows. And it's been a little bit light, not only for hard rock and coal, but also for construction materials. So we're looking at a way of stuff to maybe freshen those up a little bit so that we can get some solid nominations. For some reason, it's really hard to get companies and stuff to toot their own horn, but we understand, you understand the stuff that that's very important work and stuff that highlights exactly why we're here and the hard work that they do. And so we're always looking for those opportunities.
Yeah, just to note, our 2024 Dr. James A. Pendleton Award was nominated by staff here this year.
Yeah.
And so then for what was the award that went on Bill, the Community Investment Award?
Yeah, it's the developed or continued substantial community partnership. So this year, we did not receive any nominations either by staff or companies, but in the past, we have. That's generally one that is a popular one, but for some reason or another, this one just didn't come up.
Any other questions? Well, thank you very much. It's a wonderful program to see the positives. Results behind us. Great program. Thank you for your contributions. All right. There is no public comment today and no need to go into executive session. So we are adjourned for the May 2025 Wineland Reclamation Board meeting. We'll see you in April.
Thanks, everybody.
Wants to Stick around, like I'll be here anytime now. I had it scheduled for 10:30, so hopefully.
Oh.
Yeah.
Too efficient today, Madam Chair.
She usually runs out the door before.
I didn't even know.
Did you, in your board packet, did you have
One of those. Yeah. You've got a lot more to do.
Running out?
I don't know about that, but.
Yeah.
Well, I didn't get one, so I was wondering, so that's fine, it's just me, so all that Amy and but it's just when they did it, I didn't get one, so that's fine.
Candy, sorry, I missed the luncheon.
Whatever. I got you for tomorrow, so.
I'm in for tomorrow.
And even
So-
still,
There we go.
I guess they need.
I already know what you want.
Yeah.
Because you always stick with the Italian,
No,
like
I mean,
always.
Or you can give me whatever and I'll.
I'm like, no, and so even if you don't answer me, you're still gonna have something right downstairs.
Did we, where are we meeting for tomorrow?
I've seen the number.
Very-
Yeah, that's gonna be about 11.
How big is?
That's when lunch is supposed
I
to
got
be here.
35 acres, but
But it's just.
I'm right on 115.
Where do we meet?
Across is Fort Carson.
Here.
Okay. Oh, yeah,
It's-
yeah.
It won't be free,
A lot of-
no, it's gonna be
A
down.
lot of wildlife.
But
down in Fort Carson.
That's our office.
Okay.
The Senate, so.
Oh.
And we've
Come on
always
down,
done
hang
a lot
out
of.
for a minute.
went through.
Yeah.
Then everybody.
I
comes on.
scheduled-
Because I'm
I scheduled
representative
that.
from the
What?
CSC.
With the turkey.
I think that's right, Bob. I was thinking about that this morning.
And,
Because I was thinking last year.
You know,
we
sort of
came-
big coyotes.
What?
That's-
No.
I've seen coyotes in Illinois.
I made it easy.
Yeah, right. In, you know, in the suburbs, coyotes.
And then.
They can live anywhere they want.
You're right.
We have a lot of mountain
It's
lions.
made a special-
Yeah.
We may need your help at the beginning of next year.
Yeah, it's funny because I was thinking about that the other day is I think because you're appointed directly from a
That's another board.
distance, yeah, the
State, another
district.
state board, yeah.
Yeah,
I don't.
I'm
exactly
good.
when that is.
Don't need to.
Yeah, take that
do it.
run,
Yeah,
like,
like,
you
don't
know?
need to do it. Just, don't want to be stepchild, right?
You're gentle and all that kind of stuff.
Normally.
Yeah.
I don't think there's you and that one.
I'd be-
Okay,
I'd be-
okay, so that would be great. You know when rulemaking's gonna be? Rulemaking.
I wrote it down.
I did too. It's somewhere. And Russ just told me.
That Russ question, yeah, I don't recall what his specific.
I think I'd have to leave it.
Oh, we were just talking and she would.
To be sure.
Now, that's a strong love.
Okay.
That is, well, okay, like,
Willing.
no,
I'm
she
with
very
you. No,
well.
I'm very-
Very well.
Covered.
But that's,
We appreciate
we've got someone
No,
who
no,
actually
it's
says, yeah,
And then I feel like walking.
who's kind of in the midst of it all the time.
I don't feel like.
It'll be-
Yeah. It'll be good. It's always
Only
good.
2 blocks. It's only a block, not even a block.
I'm working on it. I'm just waiting for the phone call.
What's that? Oh, yeah, no, we're good. It's all right, we're good.
Well, I know that she knows something about that,
No, 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 it's all
so.
right. It's all good. Thanks. Appreciate you doing that. Thanks.
Like I said, I worked for 10:30, so.
Yeah, I just walked up.
I love it when they're late.
Yeah.
It's nice to see longer. I'm just gonna try to get
Dewinterize.
recall on my car.
We're getting out that
No,
week too.
Yeah.
We will.
How did the hotel go?
Yeah, I'm out of here. I'll see you next time.
Good.
Okay, you're not gonna stay for lunch?
Except they wanted me to fill out.
No, is they bringing lunch?
Should be here anytime now. I'm just waiting for it. Supposed to be here between 10:30 and 11. I ordered it for 10:30.
So it's.
But because I knew we were gonna be done.
Done earlier than we thought.
We're done earlier than we thought. That's the problem. You guys just skip on right on through things instead of asking a bunch of questions, and I would be more on time. Or at least it would appear.
We've got a couple.
And they wanted me to fill this out and I looked at, actually, all the answers, a lot of them.
No, that wouldn't be fair.
Yeah, I'm just.
They already have my information. We've already gone through it. And I actually, there's one guy that I deal with a lot of the same.
I know.
And he's out.
I mean,
And so, we've got it all situated to where now what they're doing is they're holding my product.
Well, it better be as good as it is here.
And then they took one part.
To go away, like, exactly, beach weather area.
And I think I finally got it. to where
Exactly. You're gonna get a blizzard, you're gonna get 70 degrees, you're gonna get everything in between.
Yeah, it was. I was down feeling-
Actually, we all want you to go somewhere, so it's perfect here for us.
Exactly.
Yeah.
So they have, I've got this and I'll make sure that, but as long as.
Collect the taxes, spend them, but we don't
Okay.
I'm just on my daily, but no, in fact, I already saw your bill come through.
And afterwards,
It's
it's
all under my.
we just destroyed.
Which is exactly what I was.
Fine with me. So the other.
Figured out, not everybody at the front desk is.
Okay, well, we'll see you tomorrow then.
Yes,
I
looking
mean, they
forward to that.
recognize.
Cecil, thank you.
All right. you guys.
Oh, they know me now. They know my phone number now too. I'm like, what is this?
Okay, see you tomorrow.
Okay, I gotta go right downstairs real quick. I'll be right back. Got lunch or anything.
And I.
Hopefully I'll bring lunch.
Right. That was a mine.
Thank you, Kim.
No, I thought it was actually, I mean, they have a pivot on it.
They had a permit, yes.
No, they have a pivot on this, I mean,
I remember looking at
The-
the weather and thinking.
I know what you're talking about. And,
Stormy for a while.
I don't know, I mean, I don't know that it adversely affects agricultural property. I do know that it can adversely affect residential property. And I live on a road that goes to a forest. And it's a big forest. I mean, it's not a big, it's a real deal. So I've got semis going all the time on my road. I think it affects residential property. I don't think it affects, if run properly, I don't think it affects agriculture. But, if it's not run properly.
Just to let y'all know, it just showed up.
So, yeah, I know. And then again, I mean, that's what you gotta think, you gotta say to yourself. Right? And then there are certain things that we can consider.
Is there a lot of snow out in Kersey?
That we can't consider.
You know, it wasn't, not too much accumulated. The wind was so bad, but like, so I got this morning and I'm like, should I take the truck into town or the Prius? And everybody's, oh, it's fine, the Prius. And there was like glazing across all the country roads, you know, like that much water froze. I'm like, oh. But yeah, no, not too much snow though.
Good.
The board
I mean,
recommended-
somewhere they closed.
Oh, going that
70.
way. Yeah, going the other way. Even the truck would have been, yeah, no. Yeah, bad out there.
I was going home last night and it's weird, cause it's kind of starting to sprinkle, you know, around Sheridan as I was heading west on 6th.
If you really want.
And I was coming through about a little after 7.
You take the water over.
And from
And that would be true too of an agriculture.
Sims
An agriculture.
and I-70, just for that stretch, there was like an inch and a half of snow already on the ground. I mean, I put it into more four-wheel drive and then as soon as I got on I-70, it was wet. And then once I got past Morrison, completely dry.
Right.
It was so weird. It was just